For delivery of order, item number 1, bail application number 2825 of 2024.
Petition dismissed.
Obliged.
My lord, I beg to mention item number 7 and 8, my lord. My lord, here, my lord, the parawise comment yet we have not yet received, my lord. I've taken consent of other party, my lord. Let this matter released after 4 weeks, my lord.
You inform the other side?
Yes, my lord. Yes, my lord.
Mr. T. Tagum, learned counsel for the respondent.
Yes, standing counsel to Education Department.
Education Department, praise for listing the matter after 4 weeks. So as to enable him to file. Mr. T. Tagum, learned counsel for the respondent. Education Department. With consent from the other side, praise for listing the matter after 2 weeks. 4 weeks.
4 weeks, my lord.
After 4 weeks. So as to enable him to file affidavit in opposition. Here is allowed.
Deeply.
Oh, how many days you have not filed the affidavit?
My lord, in 2, my lord. 7 and 8, my lord.
No. In for how many days you have failed to file the affidavit?
My lord,
Matter was of 23.
23, my lord. The parawise comment, my lord, I sought for, my lord. Yet I could not receive, my lord. That's why, my lord. I have to take a further, my lord, the reminder, my lord. Within this 4 weeks, my lord, I'll try, my lord.
Your Lordship, item number 7, there is a status post that may be maintained, Your Lordship.
6 and 7.
No, only 7, my lord.
7, Your Lordship.
7. Okay. Till then, interim order pass in item number 7. Shall continue.
Okay.
My lord, I beg to mention item number 22. My lord, I on behalf of Gamkin Bam, the leading counsel T. Taras is out of station. my lord.
On behalf of?
On behalf of Gamkin Bam, G Bam.
Acha.
And I,
You inform the other side?
Yes, Your Lordship. Yes.
yes.
But Mr. T.T. Tara is for the appellant and for the respondent both the sides.
It has wrongly been reflected, Your Lordship.
Wrongly.
Yes, T.D. Tara is for appellant, Your Lordship.
Hmm.
That's wrong.
Mr. Your good name, please.
N. Karg, my lord.
Learned counsel appearing on behalf of Mr. G. Bam, learned counsel for the appellant. With consent from the other side, press for listing the matter after
2 weeks.
2 weeks. Fair lord.
May it please, Your Lordship. Lordship,
Yes.
I beg to mention item number 12 and 13. Your Lordship, I'm making the mention on behalf of Mr. D. Soki, Your Lordship, for the private respondent. He has taken consent from all the parties, Your Lordship. If I may pray, Your Lordship, this matter may be fixed on 17th, Your Lordship.
17.
Yes.
Ms. T. Jene, learned counsel appearing on behalf of Mr. D. Soki, learned counsel for the petitioners.
Private respondent, Your Lordship.
Learned counsel for the private respondents. With consent from the other side, press for listing the matter on 17th of December. Fair lord.
Deeply.
May I, Lordship? Lordship, I beg to mention item number 4. From the I have taken the consent from the other side. The matter may be, Lordship, taken after vacation, Lordship.
When?
After vacation.
Your good name, please.
B type of deal, Lordship.
You are for the respondent or
Respondent, yeah.
learned. Who is for the petitioner?
I am, my lord.
You.
No.
Any objection?
No, my lord. Interim order, my lord.
Learned counsel for the respondent with consent from the other side, press for listing the matter after vacation.
Lordship.
Fair lord.
Obliged. Lordship.
Interim order is there, my lord.
Interim order passed earlier, sir, continue.
May I sign, my lord?
Hmm.
Here is, my lord, very strange situation, my lord. I will start from page number 20, my lord. Page number 20, my lord, my lord.
Hmm.
Serial number 5, my lord, is me, my lord.
Yes, Mr. Tisha,
My lord.
under what authority he has issued such an order?
Yes, my lord, I have the instruction, my lord. Your lordship may interfere, my lord. This order has been passed without any authority, my lord.
Hmm.
PD does not have the authority, my lord.
Hmm.
So, my lord, this matter may be disposed of by interfering the impugn order, my lord.
By setting aside
Yes,
the interim order.
My lord.
Heard Mr. L. Parme, learned counsel for the petitioner. And also heard Mr. B. Pisa, learned standing counsel for the respondent authorities. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order. Number KKD stroke PD, which will make it RD, stroke ESPP dash 10, dated 16/9/2024, issued by the project director R&D Colorian, Kurumkume district. It is to be noted here that by the impugn order dated so and so, the learned, no, the respondent number is respondent number,
4, my lord. I
uh,
will respond. 4, my lord.
not 4. Respondent number 3,
Three,
project
yes,
director.
ma'am, 3, yes.
Respondent number 3, the project director R&D department, rural development of Kurumkume district. Impugn order is at page number
24.
24, my lord. 24, my lord. Annexation number 4.
by the impugn order dated so and so, which will make it annexure number 4, has directed no, has assigned the work, no, assigned the charge of EO, which will make it RE, CD dash block Sangam under RD department to look after, no, no, assign the charge of so and so to one Sri Hilang Tatu to which in JE, which will make it WRD subdivision Sangam. In addition to his duty, in addition to his own duty, till further order. Sir Parme, learned counsel for the petitioner submits that the petitioner was posted as EO, which will make it RE, when he was posted there
On 11 November 2023, my lord.
on 11 November 2023.
And
Where you have mentioned it?
Page 20, my lord.
page 20, my lord.
Serial number 5. Student number 5 is the petitioner, my lord.
Void order dated 11th of November 2023, and since then he was discharging his duty sincerely. But void impugned order dated 16/9/2024, the respondent number 3 allowed to take charge of the post of the EO, which will make it RE, where the petitioner was serving, to the private respondent number 4 without any authority and power. As only the Secretary and Director of Rural Development Department, Gautam, Arunachal Pradesh, has the authority and power to transfer the petitioner. And as such, the impugned order dated 16/9/2024 is illegal and arbitrary, and therefore Mr. Parme contended to set aside the impugned order. And what is this page number?
Page number 26 is our, my lord, so cause notice, my lord, to the project director, my lord. Page 26.
26.
26, yes, my lord.
26.
So cause, my lord, yes.
25, I make a representation against the impugned order, my lord, before the competent authority, that is director, my lord.
Mr. Parme also submits that on receipt of the impugned order, the petitioner has filed on a representation to the Director of Rural Development Department, Dr. Arunachal Pradesh, on 7th of October 2024. And thereafter,
On
the
such representation, this 20 page number 26, my lord, competent authority issues of not
Ah,
No.
and on the basis of said representation, the Director, Rural Development Department, Itanagar, has issued so cause notice to the respondent number 3.
Three.
Respondent number 3. And on such ground, Mr. Parme, learned counsel for the petitioner, contended to set aside the impugned order. Per contra, Mr. Bisal, learned standing counsel for the respondent number 1, 2, and 3, submits that on a fairly submits that the respondent number 3 has no authority to pass such an order, no, to pass the impugned order, as the power of transfer and posting is vested with the secretary, director and secretary.
Yes.
With the director and secretary of the Rural Development Department, Dr. Arunachal Pradesh. And as such, he has no objection in the event of setting aside the impugned order and disposing of this petition. Having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on the record, and also perused the impugned order dated so and so, so and so. Admittedly, the respondent number 3 has no such authority to pass such an order. Such an order. By which he allowed the private respondent number 4 to look after the charge of EO within bracket RE, CD Block Sangam. CD Block Sangam. For which the Director, Rural Development Department, respondent number, he is a respondent number
2.
Respondent number 2 has issued a show cause notice. Show cause notice to the respondent number 3 on the basis of representation submitted by the petitioner on 7th of October 2024. Further, having considered the submission of learned advocates of both the parties and also considering the facts and circumstances on the record, and as agreed upon, this court is inclined to dispose of this writ petition by setting aside the interim order dated 16/9/2024. In terms of this, writ petition stands disposed of at this motion is itself, leaving the parties to bear their own cost.
My lord.
My appeal, my lord, this writ petition is directing against the order passed by the my lord, order passed by the general manager, or wherein my application has been rejected despite that initially my application was accepted. Now the
Mr. Modi, your candidature has been
my
rejected
candidature has been rejected
Rejected,
despite
as the land you have shown to them was registered only after the advertisement.
my lord, that is the ground.
Mm.
That is the ground
So
that
what's
the
wrong with the
company has
authority?
taken. But what my lord, my projected,
You have not fulfilled the requisite criteria, therefore your petition was rejected.
my lord, that is the contention of the, my lord, this company. But what my case is, my lord,
Mm.
despite that, before going to that, my lord, I have submitted the application and that everything has been go through by the, my lord,
That's all
company.
right, till
And
that time.
thereafter, I will take the lordship to the page number 14. My lord, may kindly see the 14A. Wherein, my lord, despite of my lord 14A, this type copy. Wherein, my lord, I was selected and I was, my lord, selected for.
Well,
But
that
my
was
lord got it, my lord.
conditional. Till that time, they have not visited your place.
My lord. During that time, they were not visited, but on the basis of my application, my lord, it was accepted, and my lord, here, what they said that, were pleased to inform you that you have qualified a lot of draw for the selection of the RO dealer. You are requested to present and personally with the photo I card issued by the government department on 4 December 2003. So accordingly, I was there on 4 December 2003. I have been invited. My lord, this invitation was done after go through the application, man. Then accordingly, my lord, may kindly come to the page number, next page.
No, they have taken the decision to cancel your candidacy
My
on the basis of the report of the land evaluation committee.
Land evaluation only, my lord.
Hmm.
So, my lord, I am aggrieved against this decision because, my lord,
So
before that,
admittedly, the land was registered only after publication of the advertisement.
that is the contention, my lord. But that was not the criteria, my lord, that which I was given, my lord. Had I have been, my lord, invited, had
Yes,
had
Mr.
this
Tapak,
been,
you are appearing for the respondent.
Yes.
What
So-
is your instruction?
Lordship, that is the issue, Lordship. I have been told that this, the petitioner is a category, case of the petitioner is fails under category 3. Because he is not the category 1. For selection, as per selection guideline, because as per the lease deed, registered lease deed agreement, it was after that, as per this, there is a guidelines in this brochure
Hmm.
in which I am told that it has to be registered lease deed has to be this there
Hmm.
with the applicant at the submission of application
Hmm.
for RO dealership, but at the hand of the petitioner that was not there.
Hmm.
That is the instruction.
And,
That is the ground for cancellation.
and I have been, my lord, directed to remit the security amount, and accordingly that was also, my lord, remitted. My lord will find in the page number 16. If, my lord, if the precedent condition of the company was that my land should not be registered after application or after filing of the application, my lord, I should have been rejected initially, my lord. Now, this is what my submission is, my lord. The company is, my lord, making the pretext, seeking for, my lord, looking for cancel my application, my lord. Otherwise, my lord, I should not have been allowed earlier, my lord, because this was done after going through all the required, because, my lord, on plain application, that application was not submitted. And one thing, my lord, the-
Mr. Tapak, was it the condition precedent that the land should be registered earlier to the publication of advertisement?
Not exactly earlier, it is as per the, as per the guidelines at the time of submission of application. At the time of submission of application for RO dealership, the applicant must have a registered list, long-term registered list. That is the condition as per the brochure. That
At
is
the
your
time of filing application.
at the time of application for RO dealership.
Hmm.
RO dealership. He was applying after, he was
Okay,
probably.
let notice go at this sisters, you file your affidavit in opposition, I
Yes.
will say. Heard Mr. C. Modi, learned counsel for the petitioner, and Mr. T. Tapak, learned counsel for the respondents. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the order intimation issued by the respondent authorities dated 22nd October 2024. The grievance of the petitioner is that pursuant to advertisement issued by the respondent authorities, he had applied for dealership, RO dealership at NH 15 within 4 km from Arunachal University of Studies towards Tezu, Namsai district under SC category. And he was invited by the authorities being qualified to participate on 04/12/2024. On who is that, Mr. Modi? Is it 4/12/2024?
24 November 23, my lord.
November or December? No, they said 4/12/24. Is it correct?
My lord, yes, on 4/12, 4 December 20, yes, 4 December 23, my lord.
You have been invited to Tinsukia.
My lord.
Is it?
Yes, my lord.
For drawing the lots, and the petitioner participated in the same, and he was declared as successful.
My lord.
Thereafter, the petitioner has submitted all the relevant documents as per advertisement dated 26/8/2023 by depositing the required amount of money.
My lord.
However, by the impugned letter dated 22/10/2024, Mr. Modi, the earlier date 4/12/2024 may not be correct.
No, that is
Maybe
4/12/23, my lord. 23. Earlier one is 4 December 23.
Yes, for December 23. And by the impugn letter dated so and so, so and so, the respondent authority has informed the petitioner that his candidature has been found ineligible. And he has been considered as Group 3 applicant. Mr. Modi, learned counsel for the petitioner, submits that by the impugn letter dated 22nd October 2024, the petitioner has been informed that his candidature has been cancelled, and the ground shown in the said letter is that the land evaluation committee visited the site offered by the petitioner on 10th of April 2024 and found the same to be not meeting the required norms as the offered land lease deed is registered after the date of application. And Mr. Modi further submits that that was not the condition mentioned in the advertisement, and as such, the impugn letter dated 22nd October 2024 is illegal and arbitrary, and therefore Mr. Modi contented to set it aside. The submission of Mr. Modi needs further consideration. At this stage, notice be issued to the respondent, returnable in 2 weeks.
And
Since Mr. T. Tapak, learned counsel for the respondent number, standing counsel for the respondent number 1 and 2 entered a variance and received notice, no formal notice is required to be issued. However, extra requisite copy of the petition be furnished to Mr. Tapak during the course of the day.
until then, my lord, the final, my lord, question in the my lord advertise may not be finalized, ma'am.
Let him file affidavit, he will consider it.
Otherwise,
Interim care of the petitioner will be considered on next date. List the matter on fixed date. Yes. When you will be able to file affidavit?
Anything.
Anytime.
Yes.
No, if you are ready to file the affidavit, then we will fix a short date then.
Yes, after 2 weeks.
1 week then.
Yes, 1 week, date may be fixed.
Yes, we will fix the date after 1 week.
After 1 week.
18.
That will.
Interim period will be considered on that day.
deeply obliged. My lord, this is a, yes, wherein, my lord, I have a limited prayer before this honorable court, seeking for the direction to dispose of the representation filed by me, which is pending before the SDO cum ADC or Nari on 13/11/2024. Here, my lord, the application complaint has been filed before the ADC by stating that, my lord, what had happened, my lord? There was a notification from the notice issued from the ADC Nari that I should remove the gate. And accordingly, my lord, I have complied the court order.
Uday, where you have enclosed the order of the High Court in
My-
your petition?
My lord, that order has not been encroached because, my lord, that is no more in the issue. What is in, because, my lord, I have been directed that you have to remove the gate. And accordingly, my lord, I have removed the gate.
No. In your petition, you have mentioned that as per direction of the High Court,
My lord,
in WBC number so and so, so and so.
CRP number so and so.
Where is
That
that
I-
order?
my lord, that I have not annexed, my lord. So what, my lord, I found it now that in comply to the High Court, that order, I have complied, and my lord may kindly come to the page number
We
10,
have to see what was the direction in the CRP.
my lord.
You
The-
produce
my-
the
my
order
lord-
on next day.
My lord, my submission is, so far the direction of the CRP is very clear and I have complied it, my lord. My lord, may kindly see page number 10, where I have admitted that I have already complied. And thereafter
No.
also, my lord,
No, Mr. Modi, we have to see what was the direction in the CRP.
my lord.
Exactly, lords. Exactly, lords. We have not enclosed.
Then, my lord, in such situation, I
We
will,
will fix it on next week.
my lord,
Produce the order of the High Court.
my lord, I will bring on record in the additional format.
Third, Mr. Modi, learned counsel for the petitioner, and Madam for the state respondent. List the matter on Wednesday,
One is the matter.
so as to enable Mr. Modi to enclose the order of this court passed in CRT number
CRP number, my lord, 54 of 2023,
by way of an affidavit.
affidavits. Of that.
Of life.
May I please, your lordship? Your lordship, the leading counsel is currently out of station, your lordship.
Who is your leading counsel?
Yes, sir.
Who is the leading
A
counsel?
Bodo, A Bodo.
A Borough.
Yes, your lordship. So your lordship may adjourn the matter for today and fix it after 4 weeks.
Is your good name?
P. Lomdak,
P.
Lomdak.
P. Lamdak, learned counsel appearing on behalf of Mr. A. Bodo, learned conducting counsel for the petitioner.
Your lordship, there is an interim in place, so your lordship, the interim may be continued.
List the matter after 4 weeks.
Yes, your
Till then interim order passes.
This matter will be listed after 2 weeks.
2 weeks. 2 weeks. Till then interim order pass earlier shall continue. Who is for the petitioner?
Mr. Kato. Mr. Kato.
Kato. Kato M. Kato.
Madam, I am sorry, madam. My friend, my lord, this matter may be taken up on Monday, my lord, or Tuesday, my lord. This morning, my lord, I came from all the way to from Guwahati, my lord. I tried.
Okay. As spread by Mr. M. Kato, learned counsel for the petitioner, let's list the matter. Tuesday then, Tuesday.
My lord.
Mr. Panging, any objection?
No.
Tuesday?
My lord. Deeply appreciated.
Your lordship, in this matter, the council on 4 occasions has not taken a fresh step even after direction of this honorable court.
Dismiss the petition.
Your lordship, in that case, I'll just inform the council on the next date, your lordship, because this is a criminal petition, your lordship.
No, criminal petition, that's all right. If the party is not interested to pursue
Interested,
the same, then
Yes.
because there is order
Mm.
dated 30th-9/2024.
Mhm. Because your lordship, at least if the councils has withdrawn their consent or not, I'll just take an information from them, your lordship.
No, on 14/8/2024, license was
Last-
given to him.
Yes, yes.
Okay. None appears for the petitioner on call. However, Ms. P. Zene learned additional AP.
Yes, Your
Additional
Lordship.
PP for the state respondent present. List the matter. Is the counsel available in the court?
I'll have to look for, because there are two councils. One is, I think, in the, he's appearing matters in trial courts, Your Lord.
Trial court.
Yes, I'll just have a look if he's
So
here. or
next
not.
week then, if nobody turns up, we
Yes, yes.
will,
Your
we
Lordship.
will dispose of the matter. List the matter on
Deeply.
Thursday. Next Thursday. In the event of subsequent non-appearance, appropriate order shall follow.
Yes. Deeply.
Yes.
Yes, my lord, I am for petitioner. Till today, my lord, only epidemic is filed by number 11, petitioner respondent 11, 15 and 6, 17. Rest, no epidemic.
Who is for rural work department?
Mr. Jimmy Tara. Mr. Jimmy Tara.
G?
G Tara.
Acha. He is not present today.
We couldn't find him out. He's absent, I think.
Absent.
Yes.
2022 matter.
My lord, the issue involved is compensation for the land, my lord. My lord, the project is PMJSY project, my lord, wherein no compensation is being paid to the landowners, my lord. In other cases, my lord, in highways and all, my lord, of course, compensation are paid to the landowners, but this is PMJSY road, my lord. In all the PMJSY road, my lord, the government do not pay any compensation for the land. If the public wants the road, my lord, government will
Ready to construct
give
it,
them the
otherwise-
road, my lord. Yes, my lord.
So is there any notification to that effect
My lord.
that no compensation will be?
Yes, my lord,
awarded
in some of the
respect
cases, I have filed affidavit, my lord, in that regard, my lord.
You have filed affidavit?
Yes, in some of the cases, not in this case, my lord, of course, not in this case. my lord. And there is notification of course, my lord. That place,
Notification.
my lord, is also aware that, my lord, there are so many PMGs road, my lord, being constructed across the state, my lord. But this is the past instance, my lord, for the PMGs road, someone is this seeking compensation. my lord.
So will I fix a short date?
No, last date may be given to file epidemic by respondents.
Okay. Third, Mr. Your good name, please.
T. Shiva.
Learned counsel for the petitioner and Madam
Oh, 1, 6, 15, 16 and 17.
1, 6, 15, 16 and 17.
Yes.
And Mr. Kamduk for respondent number
4 and 5, my lord.
4 and 5.
My lord, may direct the RW department to file it, my lord. There will be
R&D.
RWD department.
RWD.
Yes, my lord. Because the
Office note dated 5/12/2024 indicates that no affidavit in opposition has been filed by the Rural Work Department till date. Order dated 8/8/24 indicates that Mr. Z. Tarak learned standing counsel for the Rural Work Department has taken 3 weeks time to file affidavit, but no affidavit has been filed in view of the office note dated 5/12/2024. It also appears that the matter is pending since the year 2022. in view of above, the Rural Work Department is directed to file its affidavit within a period of 2 weeks from today. In the event of failing to file affidavit within the stipulated period, the court will proceed to hear and dispose of the petition without the affidavit of the Rural Work Department list after 2 weeks.
Obliged.
We'll fix it that suggest the date.
Where your lordship, lordship, I'm amicus in this case. Your
Yes,
Lordship, as per the office note, service upon respondent number 2 is still awaited.
Hmm.
And your lordship, I would like to apprise one. Here, your date of the sentence was conviction was for 10 years, your lordship.
Hmm.
And as on today, already 10 years, 1 month has been
Acha.
passed, your lordship.
The
So
person is still in the jail.
that, in that regard, we need to,
Yes, because his date of arrest was 2014, and as per the record, he was never released on bail, and during sentencing, those periods were set off, your lordship. If we calculate from that, then his sentence has already been undergone, your lordship. In that case, your lordship may direct give me a direction to
Obtain
instruction from superintendent, yes, jail authority.
whether the person is still behind the bar.
Bar on, yes. And if the person still wants to pursue, just
arrested on 2014, your lordship,
Hmm.
16/10/2014.
Heard,
And
Madam N. Onjo, learned counsel for the appellant, learned legal aid counsel for the appellant, and Madam T. Zini, learned additional PP for the state respondent. Ms. Onjo, referring to the order dated, the office note dated 5/10/2024, Summits that service of notice upon respondent number 2 is still awaited. Further, Ms. Onjo submits that the appellant was convicted for a period of convicted under section 307/326 IPC and sentenced to undergo sentenced to suffer imprisonment for 10 years.
are right 10 years.
And the said period of 10 years already elapsed.
yes, yes.
And as such, Ms. Onjo submits that the learned additional PP may be directed to obtain instruction as to whether the appellant is still behind the bar or he has been released on completion of the sentence period. Under such circumstances, it is provided that Ms. Dini, learned additional PP, shall obtain necessary instruction from the superintendent of jail
Yes.
of
Julie jail.
Julie Central Jail.
Central jail.
here.
Yes, your lordship.
Jubilee. Central jail, Naharlagun or Itanagar?
It's in
Itanagar,
Julang.
Julang.
Itanagar.
It's comes under Papumpare district, your lordship, not
Papumpara
Itanagar.
district. Okay. List the matter on Tuesday then,
Lordship.
Your lordship, if on Thursday, your lordship.
Thursday, okay. Thursday.
Deputy.
Obliged.
May I, Lord?
Hmm.
Lordship, I'm standing on behalf of El Perme. He since late on court number 2 has asked me to take for prayer for justice service upon the respondent number.
It's a service not completed.
Not completed. He spread for justice service, Lordship.
Mr. Riam, you are appearing here? This CRP?
No.
No. Heard Mr.
V Jamo on behalf of El Perme Lordship.
Learned Counsel appearing on behalf of Mr. L. Parmin, Learned Counsel for the petitioner. Office note dated 4/12/2024. Mr. Parmin is here.
Oh,
Heard Mr. L. Parmin, Learned Counsel for the petitioner. Office note dated 4/12/2024 indicates that service report in respect of sole respondent is still awaited. Mr. Parmin, Learned Counsel for the petitioner submits that he may be permitted to pause service of notice upon the respondent by Dustibut. Care is accordingly allowed after effecting service upon upon the respondent by Dustibut. The counsel for the petitioner shall submit or shall file an affidavit before this court. This is the matter on when, Mr. Parmin?
After a vacation mail. After vacation mail.
After vacation. This is the matter after vacation.
Interim is dated.
Till then, interim order pass earlier shall continue.
Obviously.
Yes, next item.
Lordship, here for the opposite for the container 1 and 2 Lordship. So we
No,
file our affidavit in deposition Lordship. In our reply we have filed. Respondent 1 and 2.
Affidavit in reply or affidavit in opposition?
Affidavit in opposition Lordship.
You know, we'll file a rejoinder within a week, Your Honor.
You will file a rejoinder.
Yes, Your Honor.
Heard, Mr. Your good name?
Mukbang Patel.
Learned Counsel for the petitioner and Mr.
V Jamo.
B.
Jamo.
B. Jamo, Learned Counsel for the contender. Mr. Jamo, Learned Counsel for the contender submits that he has filed affidavit in opposition today.
Yes, Lord.
Today. The Learned Counsel for the petitioner submits that he will file a rejoinder to the affidavit in opposition submitted by the contender, filed by the contender. And price was granting him 1 week time.
Yes, Your Honor.
Here is allowed. Recessal is the matter after 1 week.
Much obliged, Your Honor.
Wait. I have received the affidavit, my lord will give me some time to take instructions, my lord, from the.
Affidavit in opposition you have received.
Yes.
For Mr. D. Panging, Learned Counsel for the petitioner, and Mr. I. Ram, Learned Government Advocate for the respondent number
1 and 5 euros.
1 and 5. Who filed the affidavit?
5.
Five, my lord, deputy commissioner.
Mr. Panging, Learned Counsel for the petitioner submits that respondent number 5 has filed affidavit in opposition. Then he may be granted some time to take necessary instruction in respect of the same said affidavit. Prayer is accordingly allowed. Recessal is the matter after
3 weeks, my lord.
3 weeks.
Interim, my lord.
Till then, interim order pass earlier shall continue.
My lord, the dispute here is regarding whether this government quarter allotments, my lord, they have different pools or what? We are under the understanding that it has to be, quarters has to be allotted by the Urban Development Housing Department. So this housing department may also, my lord, file their affidavit.
Yeah.
The housing department.
You are representing.
Respondent
Yes,
number
yes.
2, yes.
Now we are representing them.
Respondent number
2.
2. No, can we compel any party to file affidavit? If they
Not
do
praying
not
for
want,
compelling, my lord. If that affidavit comes, the whole issue gets resolved, man.
Then
The confusion, they should file it.
I may be allowed, Your
Mr.
Honor.
Panging, Learned Counsel for the petitioner submits the affidavit of respondent number 2 is also required to decide decide the issue raised in this writ petition. Accordingly, it is provided that Mr. Riram shall obtain necessary instruction and if necessary, if so advised,
Yes,
may file the affidavit in
Right.
opposition
yes. Obliged.
before next date.
Man.
Obliged.
LOC.
Yeah.
LOC, I am appearing on behalf of respondent number 3 to 10.
Respondent,
Yes, sir. Private respondent number 3 to 10.
petitioner is absent today. Who is the counsel?
P Topu. P Topu.
P Tafo.
P Topu.
Perhaps,
Taba Topu.
have you seen him in the court today?
I have no idea, LOC.
None appears for the petitioner on call. However, Mr. Your good name?
K lawyer.
K. Lawyer, learned counsel for the respondent number
3 to 10.
3 to 10 present. Lays the matter after 2 weeks in the event of. You
1
are
and 2, Your Lordship. For 1 and 2.
1 and 2, Mr. Riram for 1 and 2. In the event of subsequent non-appearance, appropriate order shall follow.
Clear, LOC.
Number 18 and 19.
Lordship, I have filed this IA application because in the main case under the WPC number 410. Here earlier we could not obtain all the private respondents who were being appointed as officiating personnel. Just recently we have to RTI, we have got all the posting place of those respondents. So we pray before this honorable court to allow this implicit petition. Without this respondent, then this petition will not stand, will not be maintainable in the later hearing of the case. This part is the case. Earlier also honorable court has.
So Riam, you are appearing in this case
Yes, Your Lordship. In
for respondent number 1 to 4.
in Your Lordship, item
Respondent
number
number
1 to 3.
yes,
1
1
to
to 3,
3.
Your Lordship. And in item
Or
number
Mr. A. Bhattacharya, learned counsel for the applicant, and Mr. Riram, learned standing counsel for the respondent number 1 to 3.
no, Your Lordship, government advocate.
Government
Government advocate.
advocate for the respondent number 1 to 3. This application, interlocutory application is prepared by the applicant for implementing, no, for implement of
Respondent number 4 to 85.
respondent number, implement of respondent number 4 to 85.
Yes, Lord.
85. Yeah. No, for implement of 81 persons. 81 persons as respondent. In the WPC number 410, we can make it AP 2024. As said persons are necessary party in the writ petition. Mr. Bhattacharya, learned counsel for the applicant, submits that. Counsel for the applicant submits that. At the time of filing the writ petition, necessary information in respect of the aforesaid persons, aforesaid 81 persons could not be obtained. And thereafter, by filing RTI application, the information has been collected. And the aforesaid 81 persons are necessary party in this writ petition, in the writ petition number so and so. And therefore, Mr. Bhattacharya contended that they may be pleaded as respondent number 4 to 85. Mr. Riram, learned government advocate for the respondent number 1 to 3 submits that. Any objection?
No, Your Lordship.
That he has no objection in the event of implement of the aforesaid 81 persons as respondent number 4 to respondent number 85. Where having heard the submission of learned counsel for both the parties and also considering the facts and circumstances on the record, this court is inclined to dispose of this interlocutory application This court is inclined to allow this interlocutory application. The 81 persons whose names have been reflected in the application being pleaded as respondent number 4 to 85 in the writ petition number 4110 AP within bracket, AP within bracket stroke 2024. In terms of above this, I stands closed. Necessary correction may be made in the WPC number 4110 AP 2024.
Oblations.
Is it necessary to pass order in the WPC?
WPC.
After
Yes.
after implement, we will pass order.
Yes, Lordship.
We'll take steps within 2 weeks.
2 weeks.
So there are so many respondents are there.
So after implement, the matter will be listed and then we will issue notice to them. Only after implement.
Oblations.
Here, your lordship, I am for the petitioner. There, the respondent were supposed to file their affidavit. They have not yet filed. As the. Oh, no, sorry.
My place lords. My lord, may I take lordship to the order passed by this honorable court on 22nd October 2024. Order dated 2010-24. My lord, on that day, today, my lord, the matter is fixed for consideration of my interim prayer matter. Today, this matter is fixed for consideration of my interim prayer. My lord,
But
in
the
this-
other side,
Other side, my lord, they have been duly, my lord, served, my lord.
pardon?
They have been duly served, my lord. Lord, I have taken steps through register AD as well as by way of Dusty, my lord. And to that effect, I have filed my affidavit also. My lord will kindly see this order dated 22nd of 10, 2024, my lord. Dear my lord, in respect of respondent number 1, my lord, it was, my lord, observed to be a deemed served, my lord. And my lord, respondent number 2 is a pro forma respondent, my lord. And I'm not seeking any relief from the respondent number 2, my lord.
So notice upon the respondent number 1 has been served by Dusty Mode.
Dusty Mode, my lord. And by this order dated 20th and 2024, my lord, it was, my lord, treated as a deemed served
Upon respondent number 2.
upon 1, my lord. And upon respondent number 2, my lord, they are pro forma respondent, my lord.
So why the account was raised?
My lord, in this case, my lord, it is because of my lord, my lord, I have an account. I'm an account holder in the State Bank of India in respondent number 1 bank. And my lord, what happened, my lord, that pension amount is credited in this account. And by way of my lord, notice from the income tax department, which is at page 59, my lord. My account has been freezed. My lord, one notice. This is
Whether the income tax department was made a party here?
yes, my lord. Respondent number 2, my lord. Pro forma respondent.
Union of India.
Union of India. Union of India, represented by the income tax officer, word note Lakhimpur 787001. They are pro forma, man.
Since when it is freezed?
My lord,
Since when the account is freezed?
since, my lord, 2020, my lord. And my interim prayer is, my lord. My lord, this area, my lord, from 22, my lord, this 2024, my lord, September 2024, my lord, that will be become area, my lord. That is not, I'm not claiming on that. My lord, from this December 2024, my lord, my pension account may be, my lord, released, my lord. That is my interim prayer. And my lord, the ground of challenge in this writ petition is that, my lord, this pension account cannot be freezed, my lord, because, my lord, as per section 61G of CPC, as well as per section 11 of the Pension Act, my lord, but pension account or pension amount cannot be freezed or attached. That is statutory bar is there. In spite of that, they have, my lord, attached my pension amount, my lord. Although, my lord,
Statutory bar
yes, my lord, there is a statutory bar, my lord, kindly.
in CRPC.
Section 60 of CPC, my lord. Section 60. Subsection 1G, my lord. Stipend and gratuities allowed to pensioner of the government or of a local authority or of any other employer or payable out of any service family pension fund notified in the official gazette by the central government or the state government in this we have and political person. This cannot be, my lord, attached. As for the section 61G of the CPC, my lord. And also, my lord, as per, my lord, this section 11 of the Pension Act. This is, my lord, Pension Act 1871, my lord, section 11. Exemption of pension from attachment, my lord, section 11, my lord, page 4. No pension granted or continued by the government or political consideration or on account of past service or present infirmities or is compensate allowance, and no money due or to become due on account of any such pension or allowances shall be liable to seizure, attachment, or sequestration by the process of any court at the instance of a creditor for any demand against the pensioner or in satisfaction of a decree or order of any such court. Okay. In spite of, my lord, notice being served to them, my lord, the respondent number 1, my lord, this respondent bank, my lord, they are not, my lord, made endeavor to appear before this honorable court, my lord. Therefore, my lord, my interim prayer may be considered. My interim prayer is at page, my lord, 14. My
So it is your only prayer to defreeze the account.
My lord, that is my final prayer. Now, my lord, as an interim, my lord, from the month of December, my lord, my pension amount may be released, my lord.
From the month of?
From the month of December, my lord.
December?
December 2024, my lord.
2020?
24.
24.
24, my lord. Error will be there, my lord. It will be subject to this writ petition, my lord. The area from 2022, my lord, this October.
No, if the respondent authority did not contest the matter,
then, my lord, it can be, my lord, dispose.
We can finally hear and dispose of the matter.
That can be, even that, my lord. Since from, my lord, the last 4 years, my lord, I am not getting my pension amount, my lord. I am a widow, my lord. And they are not deliberately not, my lord,
appearing before this honorable in spite of the notice, my lord.
No, whether notice upon the respondent number two is served or not.
My lord, I have taken a step, my lord, they are performer respondent only. Because, my lord, if your lordship comes to page 59, my lord, this is just a notice from the income tax department. There is nothing in this, my lord, notice to freeze my account. Kindly come to page 59, my lord. And against this, my lord, notice, I have filed an appeal before the income tax officer, and that is income tax commissioner, that is pending.
59.
59. This is notice under section 226(3) of the Income Tax Act 1961. My lord, this is written to the branch manager, State Bank of India, Naharlagun branch.
And whether the State Bank of India has passed any order upon this
No, my lord.
freezing your account?
No, my lord. Nothing, my lord. And no notice has been given to me, my lord, prior to freezing my this pension account, my account. This is just in, my lord, demand note.
Is there any retaining counsel for the State Bank of India?
My lord,
Is there any retaining counsel for the respondent?
standing counsel is there.
Yes.
Standing counsel
Who
is
is?
there. Yes, he is, I think, Miss Karga.
Miss?
Miss Karga. Yomrit Karga, my lord.
Do you have the number?
The
You have the contact number?
No, my lord.
Whether any letter of absence is filed by advocate?
No, my lord.
No. Is there any? No. Heard, Mr.
H. Lampu, man.
H.
Lampu.
Lampu, Learned Counsel for the petitioner. In this petition under Article 226 of the Constitution of India, the petitioner, Srimati Nani Yadi, wife of late Nani Tesang of Naharlagun, has challenged the legality and validity of the notice under section 226, which will make it 3 of the Income Tax Act 1961, issued to the branch manager, State Bank of India, Naharlagun branch, Naharlagun. This notice was issued to deposit 13,55,310 rupees
Yes, my lord.
in the account of the central government.
Yes, my lord. This is, my lord, the,
Whether that account was deducted from, that amount was deducted from your account,
no, my lord, not deducted.
not deducted.
No. And against this, my lord, I have filed an appeal, my lord.
Then where is the request for freezing the account?
There is nothing, my lord. That's why I'm submitting, my lord. In this notice, there is nothing as such, my lord. This State Bank of India has, my lord, freeze my account in their own policy, my lord.
Hmm. What is the last line? It is to be noted here that White White notice dated 25/2/2020. The performer respondent number 2 represented by the income tax officer North Lakhimpur and TPS has asked the branch manager State Bank of India Naharlagun branch to pay a sum of rupees 13,55,310 rupees along with interest payable by the petitioner on account of income tax for the year 2017-18. And the aforesaid amount has to be deposited by Salan to the credit of the central government. The learned counsel for the petitioner submits that on the basis of the aforesaid letter dated 25/2/2020, the State Bank of India, the branch manager State Bank of India Naharlagun branch has freezed the account of the petitioner, and the petitioner has been drawing her pension in the aforesaid account. And since the year 2020, she could not draw her pension amount and she has been suffering a lot. And therefore, Mr. Lappo, learned counsel for the petitioner, contended to issue necessary direction to the respondent number 1 to defreeze the account of the petitioner. Mr. Lampo, learned counsel for the petitioner, also submits that in view of the provision of section 60, between bracket 1 CPC, and also under section 11 of Pension Act 1871, the respondent number 1, that is the State Bank of India, cannot freeze, stroke, block pension bank account on the direction of the Income Tax Department. Is this judgment submitted by you?
Yes, ma'am. Earlier.
And in support of his submission, Mr. Lampu has referred to a decision of High Court of the State of Telangana at Hyderabad in G. Surya Kumari versus Union Bank of India and another, reported in 2022, 3 ALD 673.
Paragraph 9 will be relevant. 6 and 9. Paragraph 6 and 9. Paragraph 6 and 9, ma'am, that will be relevant. In this case. And also, in this judgment, my lord, which I am relying on.
Also take down. The learned counsel for the petitioner further submits that during the period of demonetization in the year 2016, the petitioner has sold a plot of land at her native place 0 for the educational purpose of her children and deposited a sum of rupees 12,50,000 in her said account. Without knowing the complexities of the situation, and consequently the same gets the eye of the income tax department, and she was served with a notice under section 142(1) of the Income Tax Act. And thereafter, the petitioner has filed an appeal before the
Commissioner, it is a page, 61.
before which authority?
Commissioner. This Joint Commissioner Appeals,
Before the Joint Commissioner,
within bracket appeals, my lord.
Joint Commissioner Appeal situated at
My lord, it is situated at. Just a minute, my lord.
Joint Commissioner of Appeal, and the said appeal is yet to be disposed of. Yet to be disposed of.
ITO Jorhat. Joint Commissioner within bracket appeals, ITO Jorhat.
Jurat,
Jorhat.
ITO Jurat. It is to be noted here that none appears for the respondent number 1 and 2. Though notice upon the respondent number 1 was served by Dusty Wood. And notice to the respondent number 2 was sent by registered post.
Yes, ma'am.
With registered post. Having heard the submission of learned counsel for the petitioner, I have carefully gone through the petition, the documents placed on record, and also perused the notice dated 25 to 2022 issued by the performer respondent number, no, issued the performer respondent number 1.
Too much. Performance.
Performer respondent number 2, before the performer respondent number 2, by the performer respondent number 2. And the other documents enclosed with the petition. It is well settled in the decision of Jharkhand in Telangana High Court in the case of Z. Surya Kumari that there is a statutory mandate favoring attachment, sale of pension amount. and thereafter directed the bank, respondent bank, to defreeze the pension account of the petitioner of the said case. A careful perusal of section 11 of the Pension Act 1871 indicates that no pension granted or continued by the government or political considerations or on account of past services or present infirmities or as a compassionate allowance, and no money due or to become due on account of any suspension or allowances shall be liable to be seized, attached, or sequestration by process of any court, at the instance of a creditor, for any demand against the pensioner, or in satisfaction of a decree or order of any such court. A careful perusal of section 61Z of the CPC also indicates that a pension account cannot be frozen or attached taking note of above legal proposition and also taking note of the submission of learned counsel for the petitioner, and also considering the fact that the respondent authorities have not contested this petition, this court is inclined to allow this petition by directing the respondent number 1 to henceforth to forthwith defreeze stroke to defreeze the stroke unblock the pension account of the petitioner to the extent of her pension amount, to the pension amount. The petitioner shall obtain a certified copy of this order and place the same before the respondent number 1 within a period of 1 week from today. And on receipt of the same, the respondent number 1 shall carry out the direction indicated in the aforesaid paragraph within a period of 2 days from the date of receipt of certified copy of the order in terms of this writ petition instance disposal.
Obliged, deeply obliged.
Number 21.
May it please your lordship, here, union were supposed to file a affidavit, your lordship.
Your lordship, I'm appearing on behalf of Mr. M. Kathur, learned PhD. As per his instruction, lordship, he has received the parawise comment, so he needs some more time to file his affidavit.
Heard Mr. Bhattacharya, learned counsel for the petitioner, and Mr.
A lawyer.
Learned counsel appearing on behalf of Mr. M. Kato, learned DYSGI. Mr. Lawyer, learned counsel appearing on behalf of Mr. Kato, learned DYSGI submits that Mr. Kato has received the parawise comment and he will be filing affidavit within a period of
2 weeks.
2 weeks from today. And therefore, press for granting 2 weeks. Here is allowed, rest is a leisure matter after 2 weeks.
Highly obliged.
Number 23.
Lord, in this case, my lord, the husband of the petitioner is a member of my lord, police personnel of IRBN, which is a state armed force. And while discharging duties, my lord, he died of accident. Thereafter, my lord, the wife of the widow of the deceased, my lord, police personnel, approached the authority by making an application for grant of compensation under the scheme which was introduced by the state of Arunachal Pradesh in 2019. And Lord should kindly come to Annexure 6 at page 134, 38. Type copy. Have a lordship got, my lord. This is the scheme, my lord, which is called a policy decision introduced by the state government by notification dated 6 November 2019. As per this policy, all the police personnel now legal heirs of the deceased are made eligible to claim compensation, ex gratia compensation under the said scheme. Now, my lord, lordship kindly come to next page. A, at page 139, type copy, the objectives of the policy as follows. Have your lordship got me? May I read, my lord? May I continue, my lord?
Mr. Tagum, you have not filed affidavit?
Yes, they are from page
My lord, our affidavit, my lord, may not be required, my lord.
May not be required.
My lord. Because it's related to the home department, my lord. They have clarified, my lord. Home department have filed, my lord.
Acha.
He was the constable, my lord. He was serving under the home department as a policeman, IRBN.
IRBN.
Yes, ma'am. And they filed the affidavit, my lord.
Mr. Rotan, you are representing.
Yes, ma'am.
So he died in harness.
He died while performing duties, died in harness. Therefore, initially they took a
So,
stand.
Mr. Rotan, why ex gratia was not granted to him?
My lord,
Granted to his families?
my lord, his case will not be covered under this notification, ex gratia. He was assigned the duty of COVID duty, my lord, at the time of COVID. After performing duties while returning, he met with an accident and succumbed. Now this notification says about who dies while performing duty.
Oh, he was returning after performing his duties.
Yes, exactly. That's why it is not law and order duty, even disaster management duty. While, because this is a beneficial legislation, it has to be while performing, as carrying out that duty. It will not include anything which is not there, while like returning or going.
Beneficial legislation has to be interpreted keeping in mind the object behind
Yes, ma'am.
enacting
Yes,
the
ma'am.
said
Exactly, ma'am.
legislation.
Yes, ma'am.
Hmm.
So,
So interpretation should
yes,
always be
perf-
wide, not in narrow like the
no, ma'am,
penal statute.
here, because this is a beneficial legislation over and above what already benefits are given, madam.
Hmm.
For other benefits, service benefits are given, madam. These are not covered, madam. In that event, because
No,
we have,
if the person concerned attended his duty and thereafter he was returning to his residence, then if he meet an accident, then it will not cover.
madam, our affidavit also says that's why his case was not considered. Although it was forwarded for consideration, his case was not considered because it will not come under performance of duties, madam, as emphasized in this notification.
No, this kind of interpretation cannot be appreciated.
Madam, there are decisions of this honorable court, madam, Guwahati High Court also. Similar decisions, madam, where madam, this Punya Chettiasa by our own High Court, madam. Here also, the petitioner's husband was a havildar, madam, who was under the state police department.
Would you be kind enough to give me that?
Yes, I'll give. This is, I'll give 2018 Supreme Guwahati 1759. He was a havildar. He was assigned the duty of personal security officer, madam, attached to the chairman of jute mill, Silagat, and while traveling in the same vehicle along with his protectee in an ambassador car, so-and-so, the vehicle met with an accident and the petitioner's husband, late so-and-so, died on the spot. The petitioner, being the widow, had made application before the authorities for payment of compensation, family pension, and to provide a job on compensation. But the facts here also, even if he was
No. Here there was insurgency operation. The person was not in insurgency operation. The notification relates to insurgency operations.
Yes, insurgency. He was as a security guard. He was as a security guard for that protected. The accident was not
No, I don't
considered.
think that this
Even
decision
if-
will help you.
But even when he was a security officer of the protectee for this extremist insurgency case, even then he was, because of there was he was to protect from the extremists. Even then, while being a security officer also, because he died only not performing against the extremists, but only on a accident. So it was
No,
not considered.
that notification relates to counter-insurgency
Yes, ma'am.
insurgency operation. So
Here,
he
my
is
lord,
not
we
engaged in that operation. Therefore, that notification has not covered him.
No, my lord, in
Here,
that
the
event,
person was returning home after performing his duty.
my lord, I'll pray for some more time, my lord.
Why?
Because here, what our instruction has been,
Given that these type of, we have met another, this
In a similar-
additional affidavit.
In a similar situation in 2016, my lord, the person died in helicopter crash. And he was given, my lord, 50 lakhs under the same scheme, under the earlier scheme. Because here there is a specific indication that my duty is 24 hours duty. I was specially, my lord, deployed for patrolling duty. Then I was, my lord, asked to go to particular place and get information. And while he, after verification and, my lord, collecting the information, while he was on the way to police station, accident took place. Initially, my lord, they
Oh,
took a
he
stand.
was on the way to police station.
Yes, because I am supposed to, my lord, report. Because I was directed to obtain instruction, so I am supposed to report to my commanding officer. That is the, my lord, stand taken by.
Our,
Is there any command order?
Yes,
That he
yes.
has to perform?
My lord, Lordship, kindly see the FIR itself. FIR in the report submitted by my lord SP. Absolutely clear, my lord.
FIR is at page number?
FIR is annexure 7 at page 156. Yes, specifically mentioned he was on duty at the time of accident. And he has gone to cross-check the information. That some miscreants from Assam border to enter to the Daran village into Arunachal Pradesh. That was a specific duty allotted to him. And my lord, in my compilation, my lord, there is an order dated, general order issued by the authorities, my lord, on 24/4/2020. My lord, specifically indicating that his duty would be, my lord, 24 hours duty. 24/7 basis. He is always on duty. A police person is always on duty. Even, my lord, Assam, my lord, the Police Act also says, my lord, section 22 and 23. A police personnel shall always be on duty. And there is a specific order issued. Therefore, question doesn't matter whether he was on duty or not duty. And Supreme Court says, my lord, you have to give, my lord, notional extension to achieve the object.
So where is the scheme?
Scheme at page 138.
130.
38. Yes. I am covered by both the categories. There are a number of categories. Last two categories I am covered. If it is, if while performing law and order duties or disaster management duties. And my lord, UNO as well as the central government, my lord, declared, my lord, COVID is a disaster. COVID is disaster, and any person, my lord, perform duties even during the COVID period or for COVID, he shall be deemed to have performed disaster management duties.
What is meaning by this CAPF?
CA?
Category number 4. Serial number 4.
At page, my lord, kindly give me reference.
142. 142.
Oh, yes. Indian Armed Force and Central Armed Force for CAPF. CRPF, I think. That should be CRPF. CAPF.
Indian Armed Force and Central Armed Force, Police Force. Central Armed.
Sir Ratan, what is this? CAPF?
Central Armed Police Force.
CFPs.
Central
I
Armed
not,
Police
I am
Force.
also,
You belong to, you were belonging to this IRBM.
IRBM.
How this clause 4, this serial number 4 will cover you?
My lord, also kindly see. My lord,
Page
at
one.
page 139,
139.
39. There is a specific mention, IRBM. The objective of the policy are as follows: to provide ex gratia grant to all those state police personnel, namely Arunachal Pradesh Police, Arunachal Pradesh, my lord, Armed Police Battalion, and IRBN personnel. Therefore, it is covered. That motivation is applicable to us.
Mr. Ratan,
yes, ma'am.
you see this page number 156. That was lost by one constable.
Yes.
So this
There is
FIR
no
indicates
dispute.
that he was on duty at the relevant time.
Exactly, my lord. That is the point. On duty is another thing, while performing duty is another thing. That is where I'm trying to.
While performing?
Duty. My lord will see the scheme itself. If my lord will see, minutely see why this is above the normal duty, why it cannot be, it should be killed while performing duty. Killed while performing duty. My lord, all types of duty, my lord, obviously have understood that he is on duty. Yes, he is on duty. He will be presumed to be on duty. But this particular package benefit is for performing duty when killed on duty, while performing duty. Killed while performing duty.
Well, just to clarify, madam, say, well, undertaking the military operation, madam.
Yes.
And countering, he gets injured and died. And another disaster, well, carrying out the rescue disaster management, disaster operation, if he while performing that, carrying out disaster operation, rescue operation, if he died, then this, the policy madam covers. That's what.
That interpretation will not come.
Only thing is the difference while being on duty and while performing his duties. He was on duty. But what is emphasized here in the scheme is while performing duty, not just being on duty, while performing that duty. That is the interpretation and that is the idea behind this notification. It is not just that you are being on duty, so you will get this benefit. It is while performing that duty, that law and order duty, that disaster management duty, that other this duties, my lord. My lord, therefore, kindly see what this, in the interest of public service and in pursuance to all earlier government notification dated so and so, dated 24 April 2017, except and respect things done or omitted to have been done before such superstition, the governor of Arunachal Pradesh hereby pleased to adopt and notify new scheme, namely Arunachal Pradesh ex gratia grant state policies so and so policy 2019. On the occasion of 70th Independence Day, the Honorable Chief Minister has announced that the state government would frame a policy for award of
You
ex
are
gratia.
reading?
Page 138.
138? Yes.
On the occasion of 70th Independence Day celebration, the Honorable Chief Minister has announced that the state government would frame a policy for award of ex gratia payment of rupees 50 lakhs only to all state police personnel, irrespective of rank, who die while fighting who die while fighting any terrorists, criminals, underground elements, or while performing law and order duties. While performing, it is not said that just because you have assigned a duty of law and order, that any like accident occurs, which is not related to that performance of that duty. You
No, you come to this page number 156.
Yes, madam.
Uh,
Would you,
this,
I am to
first,
inform you good
this,
that today at around so and so, our constable so and so, who was on round the clock duty at Santipur Gate in view of pandemic so and was along with our section of force so and so entrusted with the responsibility of patrolling along with Porus so and so, had died after his motorcycle so and so collided with a barricade at Forest Check Gate. The said personnel, Amos Regan, was on duty at the point of time of the accident and had gone to cross-check the information that some miscreants from Assam were trying to enter the Darang village so and so. While on his return, he had met with the accident. While on his return, he had met with the accident and was immediately rushed to district hospital Roing, where declared broad dead. While after performing duty and while returning, he went and performed his duty, and while on returning, he met with an accident and he was entrusted with the duty. But what is emphasized in this policy is that while performing duty, he was entrusted with the duty immediately while performing the duty only.
No. He went to cross-check the information received about this entering of some miscreants by crossing the border. And while returning after
My lord,
cross-checking
will
the information, he
yes,
met
this
with the
is
accident.
the FIR, my lord. The findings of the board, my lord.
Findings of the
Board. Board.
At page number
At the last page, my lord, 189A.
189A.
This is the interim order.
Yes.
Cause of death in the last column. This is cause of death, my lord. Death due to motorcycle accident while returning from COVID duty at Santipur Check Gate.
This was the recommendation.
Yes, my lord.
So payment.
Yes, this was recommended, and the cause of death, what they have, this recommendation was not accepted because the district, they have to recommend, and it is for the commissioner home.
No,
So-
scheme says there are two inquiry committees. One is the district level inquiry committee on the basis of report submitted by SP. They have to constitute, and disaster management officer, all are the members. Then inquiry was conducted. Then recommendation was made to state government to accept this. State government abruptly came to this conclusion without any basis. And that's why court was, at the initial stage, court directed the responding authority to file a better affidavit. Then they came with a better affidavit relying on a notification, which does not have any retrospective effect. They said that it is excluded, accident is excluded from the purview of the notification matter.
My lord.
Now they are saying all these things.
No, my
And
lord.
Supreme Court says, duty starts from on a particular point and, at a particular point. Duty from whom? Duty from to the place of occurrence, a place of duty, and place of duty from place of duty to place of residence. That will inclusive. Number of decisions are there, madam. And Supreme Court says, even if, madam, it doesn't cover, then also you apply the doctrine of extension, notional extension. Latest decisions are there, madam.
My lord, I'll clarify that, my lord.
And 2 days back, Supreme Court, condemned. Why did you drag the police, the family members of the army army personnel and police personnel to court. By taking some decision, my lord, they have backed me into the court. And whereas, my lord, on the same occasion, my lord, they granted, my lord, 50,000, 50 lakhs compensation. Therefore, your stand should be, my lord, at least, my lord, for the welfare of the people. It is beneficial, my lord, no strict interpretation can come
Okay,
into.
let him complete it. please.
My lord, at
Yeah.
page 146 is it's the part of the policy, my lord. This is the procedure, my lord. Part 5, my lord. Student 6, my lord, procedure and recommendation of application. The application in Form A at Annexure A shall be submitted to the concerned Deputy Commissioner through the concerned Superintendent of Police, competent CAF authority, competent Indian Armed Force authority with full details along with the documents report information mentioned in Part 4. On receipt of the application, the Deputy Commissioner will get the application scrutinized through the district level board constituted for the purpose and recommend cases of ex gratia for consideration at the government. He shall forward the original application and certified true copies of the documents along with the original copy of the proceeding recommendation of the district level board as well as his recommendation. Then screening of application by the Home Department. Although first part was done, where his case was rejected is by the all application for ex gratia grants and sanction thereto shall be scrutinized, examined by the Home Department through a state level committee consisting of Principal Secretary Home, Commissioner Home as the Chairman and Director General of Police and Commissioners Secretary as the members. The recommendation of state committee headed by the Principal Secretary Commissioner Home shall be submitted to the government for approval. This for here, madam. Now, although his was done from the district level and the district board has recommended, the commissioner who is the has to again scrutinize it.
The state level committee.
Yes, state level
What
has
is the recommendation of the state level committee?
state level committee, therefore, my lord, has recommended, my lord. In our affidavit, my lord. This is our first affidavit, my lord.
Page number.
Page 12. Annexure 1, my lord. Our affidavit dated 8/2/2024. 8/2/2024. At page 12, my lord.
Page number.
12, Annexure 1.
Yes.
A meeting of the Departmental Screening Committee consisting of Commissioner of Home, Secretary Finance and Inspector General of Police Headquarters held on 17/6/2022 in the office chamber of the Commissioner of Home in connection with the scrutiny of application for ex gratia payments and sanction to the NO case in respect of the following defense IRB and APP personnel. So and so. Serial number 1 is the petitioner, my lord. So and so. Recommended by DC Lower Dibang Valley. The
State level committee.
yes, this is the state level committee. The committee examined the proposal and recommendation of the district level boards and the deputy commissioner of aforementioned district for ex gratia to the so and so. This is personal as per notification dated 6 November 2019. After detailed scrutiny of the aforesaid proposal and the recommendation of the district level boards, deputy commissioners, the committee have found that the NOK of victim personnel at serial number 3. This is found to be eligible on account of the fact that the cause of death as per the report submitted by the district level board, deputy commissioner and other relevant documents are covered under the guidelines notification dated so and so. Hence, the committee recommends for ex gratia grant payment to NOKs of the following deceased personnel: late Avatar Chakma so and so 50 lakhs. In respect of the following personnels at serial number 1, 2, 4, 5, 1, 2, 4, 5, and 6, the committee observed that these are not covered under the guidelines so and so. So late Amos Dragon so and so, this is the petitioner, and other 4 were not recommended, my lord.
What is the reason? No reason, nothing.
The-
No reason has been assigned.
My lord,
Yeah? How it
But-
is not covered?
my lord.
How his case
Yeah,
is not covered under
this,
the guidelines?
yes, my
What
lord.
is the reason?
This reason, that reason has not been provided here, my lord. However, my lord, what, as per this affidavit, they have in this affidavit, subsequent affidavit, my lord, because the court was of the view that reason has to be provided. So we have filed an affidavit on 6/4/2024, my lord. My lord, if our subsequent affidavit, my lord, 6/4/2024.
Page number.
Reasons, page 2 onwards, my lord.
6/4 by filed by respondent number
20.
2 and respondent number
20.
2 and 3. Additional affidavit.
6/4.
Yes, madam. 6/4.
What is the stand, my lord? Paragraph 3, my lord, they have.
6/4. Okay. Yes.
Paragraph 3, madam. That answering deponent begs to state that the letter dated so and so that on the above cited, it is to inform that the state level screening committee adhering to the Arunachal Pradesh ex gratia policy 2019 notified on so and so as assesses ex gratia payment eligibility for the next of kin NOK of state police personnel so and so while affected while on duty. The policy encompasses ex gratia payments for NOK of the personnel killed, permanently disabled, or in execution of law and order and disaster management duties within the Arunachal Pradesh upon the state government's request. However, it is explicitly excludes scenarios such as deaths due to vehicular, helicopter, aircraft accidents, health reasons, or accidents like falling from rock or falling from off cliff, etc., while performing usual patrolling duties as these do not align with the policy specified objective for granting ex gratia payment.
That was in 2024, my lord, notification.
And in the instant case, the petitioner's husband led Amos Reagan, ex-constable so-and-so, whose demise resulted from the collision with a barricade at a forest check gate while returning from patrolling duty. The nature of incident does not meet with the policy criteria for ex gratia compensation. Consequently, the committee was unable to recommend the case for ex gratia. This is
No, on the basis of
because
what? On
the
basis of
fact
what?
remains. Fact remains this ex gratia is, if my lord will see, the policy intention is that while performing the duties, it is just simply being on duty is not sufficient. Just, yes, he may be in law and order. Every time the police personnel are on law and order duty, every time they perform law and order duties, disaster management duties, they are there. What is required for this policy to be covered under this policy is that while being on duty and while performing the duties, just being on duty is not sufficient. Being the simple concept of being on duty, because a person who goes to duties and comes back from duty. Yes, they are treated on duty. But here, what is required is while performing the duty. Just being on duty will not be sufficient. This is, that's why the ex gratia is, compensation is also high.
No, you have referred this letter dated 28/3/2024. What is that letter?
Accident is excluded. Accident falling from rock.
No,
weight.
this letter is by the director litigation to them after the honorable court's direction for clarification on this. Then the communication was made. My lord will see 26.3, that is, we have annexed it, page 6, my lord.
Page number
6.
Yes.
This is the 26th March 2024. This. It has been addressed to senior government advocate. It is 2024, my lord. This is a communication only. It says in inviting reference to your letter dated so and so 23/2020 on the above cited, it is to inform you that the state level screening committee adhering to Arunachal Pradesh ex gratia policy to notified on so and so assesses ex gratia payment eligibility for so and so. This is same contents. Same contents. The policy encompasses ex gratia payments for NOK of personnel killed, permanently disabled, or grievously injured during operations against terrorists, militants, criminals, or in execution of law and order and disaster management duties within Arunachal Pradesh upon so and so. However, it explicitly excludes scenarios such as so and so. This is a communication by the Under Secretary Home to the senior government advocate. I don't know why my Ladakh senior is so as if we have brought in a new policy of 2024. It's not there. That is the reasoning, because this honorable court had made a query that since there is no reason in your recommendation, the state level committee recommendation.
Whether this reason can be the basis. That is my submission.
My lord, the plain, we have annexed the 2019, my lord, then the very next page, the clear page, my lord. What it says about who are killed or permanently, my lord will say, who are killed or permanently disabled or grievously, seriously injured while fighting terrorists. My lord, while fighting terrorists, militants, criminals, underground elements. These are, or while performing law and order duties or disaster management duties. The only thing we should understand is while performing duties, not just being on duty. Being on duty is a different thing. A person will be on duty till the hours he is assigned to for duty. But while performing, being on duty and performing that specific duty, if he is killed, disabled, gets seriously injured, that is where. Just being on duty will not. So in this case, it's a return from duty. He is on duty. He is still construed to be on duty. But while returning, it cannot be said that he was performing his duty.
Okay.
No. The in my lord, the page 8 also. Quantum of ex gratia grants shall be as under. So and so, 50 lakhs. This while fighting. First one is state police personnel, APP, APPBN, and IRBN personnel while fighting terrorists, militants, criminals, UG elements, or while performing law and order duties, disaster management duties in the state of Arunachal Pradesh. It is 50 lakhs. In case of injury leading to permanent disability, it is 10 lakhs. In case of grievous serious injury, 50,000. Now, in the note NB, my lord, ex gratia payments shall not be paid for performing duties other than the above mentioned duties. It talks about performance of duty. It's not just being on duty. There are so many on duty.
What is the meaning of
So
that?
there is no dispute that he was on duty.
Yes.
But your contention
Yes,
is
he
that
was-
he was not performing his
Yes,
duty. Yes.
his death was not caused
So,
while performing this duty.
okay.
He was on duty, but his death was not caused in the performance of this disaster management duty.
Okay. Okay. But he was returning after cross-checking the information
Yes.
about this entering of miscreants by the border of that Santipur area.
Yes, he was after performing duties, he was returning. Disaster management, COVID was declared as a disaster management under disaster management.
So while returning home, he was not performing his duty.
He was on duty, but he did not perform because he was returning home. He
And
had-
his performing duty ends after cross-checking of the information.
Exactly, there is this submission.
That cross-checking, while cross-checking if he is killed,
According to him,
while cross-checking if he,
Mr. Professor, please sit down.
while my interpretation is that while cross-checking, while visiting and cross-checking,
He already performed his duty.
if he is killed, my lord, if he is killed while performing cross-checking in the gate, while cross-checking in the gate and while patrolling there, if he is killed while performing, that can be.
Okay, okay.
It is not that while returning, but while doing that, conducting that, if in that there is some eventualities, some intruders might have killed him or he might have encountered with them, sustained injuries, then while performing.
Yes. Yes, Mr. Purkesto, you show me the judgment where Supreme Court has stated that till reaching his residence or
yes,
his station, he is on duty.
yes. My lord, in compilation, my lord, okay, I have given the compilation, volume 5.
Yes.
Serial number 7.
Serial number?
7.
7.
There is one judgment of 1953 Calcutta. Then one more decision. My lord, serial number 8. Serial number 8, 2014. 14 SCC.
1 minute. Yes, let us go to the serial number 8 then.
Serial number 7, serial number 8. Can you have an, my lord, can you note down, my lord? Then I will come to the judgment.
Pardon?
Can you note down, my lord? Serial number 7,
8,
9. Then, my lord, 12, 10 and 12. And my lord, 13. 1964 Supreme Court. In almost all the cases, my lord, it was specifically interpreted by Supreme Court that when duty can be said to have, my lord, completed. And it is the categorical findings of all the, in all the cases that duty starts from the residence and it ends to the place of matter of duty, vice versa. Therefore, the petitioner who was directed to obtain instruction and information, and he is supposed to collect the information and report to his commanding officer. Therefore, on the way, he died of accident. Therefore, unless and until he reaches the police station and may not inform the commanding officer, duty will continue and he shall be deemed to be in performing duties. Therefore, duty cannot be ceased to exist only after completion of the verification or.
No, that's all right. In which judgment it has been held?
Yes. My lord, serial number 10. Serial number 10, 7. First of all, now let me, my lord, refer to 7. Page 49.
7 is of Calcutta High Court.
Yes.
So let us go to the Supreme Court
Supreme,
judgments.
all right. Then, my lord, page 54. Para 8, 9. Para 8 and 10. At page 57 and 58. May I read, my lord? Page 57.
So that is the factual background.
Yes.
Let us go to the ratio of the case.
Para 10, next page.
Para 10.
Yes.
Yes.
The court in this elaborated decision, so laid down as follows. Under section so, the injury must be caused to the workman by an accident arising out of and in the course of his employment. In course of his employment. This question, when does the employment begin and when does it cease, depends upon the facts of each case. But the court have agreed that the employment does not necessarily, and when down to signal is given or when workman leaves the actual workshop where he is working, there is a notional extension at both the entry and the exit by time and space. The scope of such extension must necessarily depend on the circumstances of the given case, as employment may end on or may begin not only when the employee begins to work or leaves his tools, but also when he used to use the means of access and egress to and from the place of employment. Therefore, my lord, from this particular paragraph, you can draw the analysis, my lord, that my duty continued. Therefore, I shall be deemed to be in course of performing duties. Therefore, duty cannot be ceased to exist soon after completion of the verification or investigation.
Next,
my lord, Shwalipna Anna.
Page number?
Page number. Come on. 70, 72 to 79. Para 18, 19, 20, 23, 24, 25, 27. Person, what is it? Man, he will myself some eyesight problem.
Page number?
Page number 72.
92.
72.
72.
What? He'll read, madam. Thank you.
You will see para 18.
Para?
18 at page number 76.
76. (76) or 77?
You will receive 76. Para 18.
18.
Yes, Lordship.
Yes.
Married, Lordship.
No, that is the Passage from other judgment.
Yes, Lordship.
Mm.
Then Lordship, para number 19.
19.
Yes.
Okay.
There is another decision in M. McNeice versus IM Isaac Air 1970 SC 1906, where court said the word arising out of employment are understood to mean that during the course of the employment, injury has resulted from some risks incidental to the duties of the service, which, unless engaged in the duty owing to the master, it is reasonable to believe the workman would not otherwise have suffered. In other words, there must be a causal relationship between the accident and the employment. The expression arising out of employment is again not confined to the mere nature of the employment. Expression applies to the employment as such, to its nature, its condition, its obligation, and its incidents. If by reason of any of those factors, the workman is brought within the one of the special danger, injury would be one which arises out of the employment. To put it differently, if the accident had occurred on account of a risk which is an incident of the employment, the claim for compensation must succeed, Lordship. Unless, of course, the workman has exposed himself to an added peril by his own imprudent act.
There is no any imprudent act.
And Lordship, in para number 20, in the case of General Manager Western Railway versus Chandrabhai alias Naranbhai, 1991, etc., Madhya Pradesh High Court, Lordship. Following decision of General Manager Best, undertaking Bombay versus Mrs. Agnes, held that notional extension of employer's premises must be applied, and therefore, if an employee has died while he was going to join his duty from his house due to an accident, it must be deemed that it was in the course of the employment. Next, para 21, Lordship.
Para
21, same page.
24.
21. Below down, Lordship. Lordship, take a case, Lordship got it, where a man is going to or from his place of work on his own bicycle or in his own car. He might be said to be doing something reasonably incidental to his employment. But if he has an accident on the way, it is well settled that it does not arise out of an in course of employment, even if his employer provides the transport, so that he is going to work as a passenger in his employer vehicle, which is surely reasonably incidental to his employment. Nevertheless, if he is injured in an accident, it does not arise out of an in course of employment. It needed a special deeming provision instituted to make it deemed to arise out of in course of his employment.
These are parameters determined. When and how it cannot be said to be in course of duty.
Where?
Unless and until there is some specific duty allotted. And while performing.
Where is the parameter?
And in this case, in this paragraph, the man is going to or from his own place of work on his own bicycle or in his own car. He might be said to be doing something reasonably incidental to his employment. But if he has an accident on the way, it is well settled that it does not arise out of and in the course of employment, even if his employer provides the transport so that he is going to work as a passenger in his employer's vehicle, which is surely reasonably incidental to his employment. Nevertheless, if he is injured in an accident, it does not arise out of and in the course of his employment. It needed a special deeming provision in a statute to make it deemed to arise out of and in the course of his employment. What I mean to say, my lord, unless and until suppose a person is performing duties and he performs his duty, but in the meantime, one more other duty was assigned to him and he performed. Therefore, second duty is incidental to the first duty. He was deployed for patrolling duty. Later on, he was assigned with the duty for investigation. And investigation, on completion of the investigation, he was on the way to report the commanding officer. He died of accident. That was assignment of, my lord, further investigation in the border area to prevent the miscreants that is incidental to original duties. Therefore, it shall be deemed to be, my lord, in course of duties and in performing course of performing duties. And Supreme Court said, my lord, Lordship has already, my lord, gone through, no final explanation has to be given.
So any other decision on this point?
My lord, serial number 15 also, that is our High Court decision. 2001 GLT 27.
Serial number
15. Paras 9.
No, that is a accident case perhaps.
By accident.
MB Act, case under MB Act.
Yes. And on the other hand, my lord, Lordship, it is my duty to point out that he was declared martyr.
Declared martyr?
Yes. And I have annexed the, my lord, copy in volume, in this volume of Mr. Miller.
Page number?
Page, my lord, 4. Page 4. My lord, serial number 71.
Who declared him as martyr?
Government, state government. And the person who died of by 2016, my lord, in air crash, my lord, helicopter crash, he was equally declared as martyr. And next page, Lordship will from at page 5. The government of Arunachal Pradesh Home Department took a decision to, my lord, award 50 lakhs to Nada Asa, to widow of the deceased IRBN constable. He belongs to same, my lord, police force, Nada Umbing. Nada Umbing, along with 3 Indian Air Force personnel, lost his life in helicopter crash in Hostalam at Papumpare district on 4th July 2000 of this year, 2017. And he had been attached with Sanso, and he was ultimately granted compensation. So he was equally declared as martyr, as that of the deceased husband of the petitioner.
Yes.
And Lordship, kindly, my lord, have a look. My lord, page 1. Page 1, this is the general order issued by SP Police Lord Dibang Bhadi District, Roing. Serial number 14 at page 1. Name of the deceased, my lord, reflected. And Lordship, and on left hand side, middle portion. Serial number 2, just below this serial number 2, left side. Column number 2. 24 into 7 hours duties. Therefore, it is an admitted fact that he was on duty and, my lord, in course of performing duties, he died. And performance of duty cannot be given, my lord, very, my lord, limited, my lord, interpretation. It has to be given a wide interpretation so that object of the policy may be achieved. And my humble submission is that, my lord, they, my lord, pressed, my lord, lot of emphasis on a particular expression, performing duty, in course of performing duties. In my understanding, my lord, I submit that performance of duty will continue till he reaches the police station. Because he is supposed to report. What information he has collected, he cannot just, my lord, keep it in his pocket. Therefore, it will continue and performance shall be deemed to be continued.
Okay.
And my lord, I'm not going to trouble your lordship by citing other decision.
Not necessary.
Unless-
So only one point is to
Only
be
point is-
decided here,
Yes,
that whether he was performing his duty.
or he was in course of performance.
Employment, course of employment, on duty and performance of duties. My lord, these are the things, my lord. And my lord, what is there in their compilation, we have not been provided, whether it is matter if the government has declared or not, that we don't have.
You want to reply to that?
If required, because they have not put it in the form of an affidavit. And what I believe it is,
Have you, Mr. Prukasa, have you supplied the copy to him?
no.
No.
Right now I can supplement.
No.
Right now you can supply. Okay, we will keep it as parted.
Yes.
Mr. Ratan, you can reply on Wednesday.
Because this
No,
is
what is-
not in the form of an affidavit also.
No, maybe.
Maybe it's a part of record. No, if it is a part of record, not necessary to file an affidavit.
It's not.
You just verify.
Part of record.
You better obtain instruction whether he was declared or not.
No, he submitted this volume
We have not been,
at the time of argument.
Yes.
we have not been provided.
You want to, if you want to reply
Yes, ma'am.
upon this, you can, but
Yes, madam.
let it be on
We would like to
Wednesday.
reply. Wednesday.
Wednesday,
No, your part is over.
my part is over.
Over. Someone can represent you.
Yes, ma'am. Wednesday, we'll seek instruction whether he has been declared mitral or not.
Yes, yes. only
And
that.
then whether the earlier this falling from helicopter, whether it was under the 2017 notification or under the
Current
2019.
notification.
I am the American, I can ensure your lordship,
We
my
have
43 years
to-
of practice, I burden my head, my lord, I will never cite any decision which is not at all correct.
Whether it was
I can-
under
I
the
can- I can say-
2017 or
I
2019.
can say
It's a-
proudly, madam, strongly. I will never rely on any document which is not a part of record. After getting verification, after getting information, we got the information because wife is the best person. At the time of awarding the, my lord.
No, I'm not disputing that. I'm not there.
No, no,
I'm
okay,
not
okay, okay. Third, Mr. Prakash, learned senior counsel assisted by Mr. S. Sharma, learned counsel for the petitioner. And Mr. N. Ratan, learned additional advocate general for the respondent number
1 and 2.
1 and 2, and Mr. Tagum for respondent number
11, man.
11.
1, 2. Sorry, man.
Main is there.
1, 2, 3. 2, 2. 2 to 2 to 10 and 12.
2 to 10 and 12.
11.
I'm
Mr.
for
Tagum.
11.
You are only for 11.
11.
Who is for 1 then?
One has been
Government.
union government, madam. That has been struck off, I believe, madam.
My lord, may I just, my lord, make a request? One more case is fixed on Thursday by VC. So lordship, can we take up the matter on Thursday? But I can avail the, my lord, opportunity of VC.
So, is it necessary that you have to appear?
Just, my lord, just to observe what my learned friend says.
My lord, may
I'm not
direct to
saying-
provide me with that compilation
Yes,
because we have
provide.
not been supplied.
For you, furnish a
So
copy. of
data is
the
there,
petition.
data is also there.
List the matter as parted on
Yes,
Thursday.
Thursday.
Okay.
And I may be given the opportunity of VC.
No, he will only make his submission
Yes,
on
yes.
the case laws
Yes, sir.
referred by you.
But if he interprets the decision of the Supreme Court in other words,
No,
then
how can a judgment, sir, not a open
may say that-
to interpret?
he may say that these decisions are not relevant, distinguishable. That.
Oh, of course, he may try to distinguish.
Yes, sir. Then, my lord, of course, my lord, I will have my liberty to
Okay, then, okay, all right.
oblige. You.